All right, we're live. Hi, everyone. Thanks for joining us today. We're just going to wait about another minute or two, let some additional people stroll in, and then right around noon, we're going to get started. All right, give it about another 30 seconds, and we'll get the webinar started for everyone. Today, we're going to talk about immigration options for Canadians. All right, so let's get started. Like I said a second ago, we're here to talk today with everyone about Canadian option or immigration options for Canadians. Specifically, the focus of this webinar is going to be on employment-based options, and of course, the most utilized employment-based options. The U.S. immigration system has a plethora of visa categories, but not all of them are relevant. So today we're going to focus on the most relevant in the categories that are most commonly utilized and most beneficial to Canadians looking to work in the U.S. So just to introduce myself, my name is Zach Hallstrom. I'm a senior attorney here at Berardi Immigration Law. I'm joined by my colleague Ruth Garbanzo, who is another attorney here at Berardi Immigration Law. And yeah, we're just going to dive right into it. So the first category we're going to discuss today is the TN. And Ruth, why don't we start with you? Give us a little bit of background about the TN, the requirements, the application process, and maybe some of the common pitfalls that we see with this category.
Yeah, thanks, Zach. As Zach mentioned, my name is Ruth. I'm one of the attorneys here at Berardi. And with the TN, this is a great option for Canadians. One of the most straightforward paths to be able to obtain work authorization here in the States. This category is specifically designated for either Canadian or Mexican citizens in certain professional occupations under the USMCA, which formerly was referred to as NAFTA. So some examples of the professional occupations include an accountant, registered nurse, pharmacist, architect. Those are some of the occupations that you'll see. And in order to qualify for this visa type, some of the key requirements include having a job offer from a U.S. employer. You have to be one of the listed occupations under the USMCA, and you have to have the requisite qualifications to qualify for that occupation, whether that's a degree or a professional license. And what does it look like to apply? The benefit of the TN for Canadians is that you can apply right at the border, meaning that you can apply at a land port of entry, or you can apply at a pre-clearance airport. This is fantastic because you get an adjudication right on the spot. If you're applying at a land port of entry, depending on where you apply, you may have to schedule an appointment in advance. Just to give you an idea of what that looks like, at the Buffalo Port of Entries, we're currently looking at about 3 to 4 weeks that they're scheduling appointments out. If you're doing it at the airport, you don't need to schedule an appointment, but you do need to have a ticket to fly into the US that day in order for CBP to adjudicate your application. And with the TN, typically you get a 3-year visa if approved. Like I said, it's immediate. So if you're approved then, as soon as you enter the States, you're already on the TN. And there's unlimited renewals. You just have to make sure that each time you're applying, you still meet the requirements for that occupation. One thing I will note, if you have an upcoming passport expiry date, you're going to only be granted the TN up until the expiry of your passport. And then once you renew your passport, you're able to capture the remaining 3-year period of your TN approval. So just a little quirky thing. And then just to go into a couple of pitfalls one thing is CBP really likes to see that the occupation you're qualifying for matches with your credentials. So, you know, if you're a nurse, they want to see that you have a degree in nursing or that you have a nursing license. Everything should just kind of, match. So that's really important. Another thing, if you have a managerial position, you may not qualify for the TN. So for the TN designation, more than 50% of your duties should fall under that typical occupation function. So if you're qualifying as an accountant, you should be doing the day-to-day functions of an accountant. That's really important. And then the other thing I was going to mention right now for adjudications is that CBP is closely looking at social media. So, they'll like to look at your LinkedIn or something like that, just to make sure that how you're applying and what you're stating you're doing matches. So that's really important. I will note that another option aside from applying at the port is to apply through USCIS. So you can mail in an application to USCIS and adjudicate it that way. The only thing is there are lengthier processing times. And if you wanted to expedite that process, there is a hefty fee to do so. So for Canadians, like I said, the best option is the fact that you are able to do it right there at the border.
Yeah, the USCIS filings are just, it's usually not something we're going to recommend to someone up front. This is a scenario that is sort of limited to, if it's the only option, we'll file with USCIS because it's just a lot more expensive in general. It's a lot lengthier. And getting to apply at the border for a TN and get a decision on the spot is a benefit. So anytime we can take advantage of that, we do. And also, there is the benefit of an in-person interview. When you file with USCIS, you're submitting a paper-based application through the mail. Officers don't have the opportunity to talk to the applicant or the company or the attorney. The way they do that is it's all paper-based. They issue requests through paper. It takes a long time and it's a lot more expensive. Where if you go to the border, you're face-to-face with the officer. If they have any questions or concerns, they can ask you right then and there. You can explain it. And overall, it is just a benefit. And just to segue into our second category, which is the L-1, the TN itself can be utilized by individuals, professionals that have a job offer from a U.S. employer. It can also be utilized by companies that have professional level employees. Maybe it's a Canadian company with U.S. clients. There are scenarios where a Canadian entity can be the sponsor for a TN application. Or maybe the Canadian company has a U.S. entity and the U.S. entity can be the sponsor. And it's just a creative way to get work permits for your people and for your team. And another creative option for specifically businesses, multinational companies, is going to be this L-1 category. This is the primary intra-company transferee visa option. So the L-1 itself is for multinational companies. So you have an office in Canada, you have an office in the United States, you might have offices all over the world. But the key is that you are multinational. And the L-1 is going to allow you to transfer your executive, managerial, or specialized knowledge employees from your office abroad to the United States. The key requirements with the L-1 can be thought of in two sort of buckets. You have your employer requirements and you have your employee requirements. From an employer standpoint, like I said, you have to be a multinational organization. You have to be doing business in the United States and at least one country outside the US, and you have to be properly affiliated. So if you have a Canadian office, it needs to be either the parent company, the subsidiary, the affiliate, or a branch of the U.S. entity that you're trying to transfer the employee to. And from the employee standpoint, it's very straightforward. I mean, they have to be a manager, an executive, or specialized knowledge. Manager and executive is a little more straightforward. Specialized knowledge has a lot of ambiguity, and there's a lot of discretion in the review process. But think of this for your highly technical, highly specialized employees that are going to be difficult to replace. That's really what the government's looking for with specialized knowledge employees is what is the burden on the employer to replace this type of employee with this type of position? If it's going to be a significant burden from a time standpoint, from a financial standpoint, then generally speaking, those are the employees that are going to qualify as a specialized knowledge employee. And similar to the TN, One of the benefits of an L1 is that Canadian citizens can apply right at the border with US Customs. So just like the TN, you take an application down to the border. Sometimes you have to schedule an appointment. You can also apply at the airport if they have pre-clearance, and you get a decision on the spot. You have the benefit of that in-person interview, and overall, it is just a benefit for Canadian citizens. And one of the nice things about this L1 is that initially you're going to get either 2 to 3 years approval, unless it's a new office scenario, which I'll mention here in a minute. And it's renewable for up to 7 years for managers and executives and up to 5 years for specialized knowledge employees. And there is an exception to that cap. So if you have employees that are primarily residing in Canada and are only using the L1 to travel periodically to the US, and they're spending less than half the year in the States, then they can technically renew that L1 indefinitely, as long as that relationship, that scenario remains true. That cap is only relevant for individuals that do relocate to the US or individuals that do spend more than half the year in the United States. So in theory, you can renew that L1 indefinitely as long as you set it up appropriately. You have an employee that's primarily residing in Canada, so it can present as a very good long-term option. And it also highlights the flexibility that you have with this category. The L1 is nice because you can use it to relocate. If you need an employee to work for your US entity full-time for extended periods, you can utilize that L1. They can relocate, they can pick up and completely move to the United States. Alternatively, they can use that L1 intermittently. There's no limit or threshold of days that you have to spend in the United States when you have that L1. You could have someone that travels once a week. You could have someone that travels once a year. That's entirely up to you and what is necessary. As long as the L1's approved, you can use it as little or as often as you need to. Now, like I said earlier, there is another way that an L1 can be utilized, and that is to set up and establish a new office. So there is a nuance to the L1 category that allows foreign companies, such as a Canadian entity, to transfer a managerial, executive, or specialized knowledge employee to the US for the purpose of setting up a new office. The key with these types of petitions is that you've secured office space sufficient for this new office. So if you're a manufacturing company, you need to have space sufficient for manufacturing operations. Whereas if you're a consulting company, the office can be as little or as insignificant as necessary. We've had clients use shared office space. As long as you have a mailing address and a space that you can utilize when needed, if that's sufficient for your business model and your company, then it's likely going to be sufficient for purposes of an L1. The only downside to the L1 new office is that initial approval, yes, you still have the benefit of submitting an application at the border, but that initial approval is going to be limited to 12 months. So there's a very short runway in which you have time to build up your US operations. And if you're not hiring employees and generating significant revenue within that 12-month initial approval, it's going to be extremely difficult to renew it. So in a lot of cases, we take a multi-step approach to companies looking to expand. If there's a time constraint and you need someone in the US very quickly to set up a new office, the L1 is likely going to be the best route. However, if you want a longer runway or you want more longevity and you're concerned about actually ramping up operations within that initial 12-month period, we then look to another option, which is the next category we're going to discuss, the E2 treaty investment visa. So just like the L1, the E2 visa can be utilized to set up an office in the United States. Now, the E2 is a little different in that the requirements are more focused on the amount of money and the investment you're putting into the US entity. So for an E2, obviously you have to have a legally established business entity in the United States. It can be a corporation, it can be an LLC, it can be a partnership. It just can't be a sole proprietorship or a nonprofit. Additionally, that US company has to be majority owned and controlled by Canadian citizens. And then most importantly, you have to make a substantial investment in setting up the organization. So for a new company, that word substantial generally means the total amount necessary to get your business to the point of operational readiness. So substantial for a manufacturing company is going to be much larger, much greater than substantial for a consulting company. It really just comes down to what your setup costs are and whether or not your company is operationally ready when you go to submit an application. One of the major benefits of this E2 is that unlike the L1, you have a much longer runway to ramp up your US company. So E2 visas are issued in 5-year increments compared to that L1 new office, which is issued in an initial period of 1 year. So you have 5 years to really ramp up and grow your US entity. The E2 is also similar to that L1, valid for unlimited entries, but there's no cap on the E2. So the E2 can be renewed indefinitely as long as you continue to qualify. The biggest thing with e-renewals is that your company is what the government considers non-marginal. This is one of the primary E2 requirements. It's still important with initial cases, but it's more important when it comes time to renew. A marginal company is one that is purely sufficient to support the treaty investor and their family. So think of a sole proprietorship, an organization that has no aspirations, no potential for growth. A non-marginal company is going to be one that has either a present or future capacity to hire U.S. workers and generate significant revenue. For new cases, initially, this marginality requirement is demonstrated through a business plan. We show growth potential. It's a forward-facing requirement that we satisfy through the business plan. When it comes time to renew, that's when the government's going to take a look at what you've done over those first 5 years. So they're going to want to see tax returns. They're going to want to see payroll records showing that you've hired workers, you have an established organization in the U.S., and it's more than sufficient for just you and your family as the treaty investor. Now, with that said, you don't have to hire 100 people. You don't have to hire 50 people. We've had very successful E2 cases with 2, 3, 4, 5 employees. The E2 is suitable for companies of all sizes, all shapes. As long as you make a substantial investment in either setting up a business, you can also purchase an existing company, then the E2 is likely a viable route. So back to that L1, sometimes if time is of the essence, we start with an L1, transition to an E2, and that's because the E2 is a different application process. So the E2 is one of a few categories that requires Canadians to actually apply for a visa at the consulate. So unlike the TN and the L1 that we talked about initially, you have to schedule an appointment at the consulate in Toronto. You have to submit an application up front for initial review, and then you have to go to the consulate in downtown Toronto for an in-person interview. The interviews themselves are pretty short, 3 to 5 minutes, typically at most, but the amount of time you spend at the consulate can vary. So it's a little more intensive and drawn out of a process because the consulate isn't a same-day appointment, same-day decision. You know, you're looking at a month, month and a half, 2 months of waiting before you actually get the visa from the date you submit the application. So for individuals that can't wait, for companies that can't wait, sometimes we start with an L1, transition to an E2. But if you do have the opportunity and the time to wait for that E2, that's usually going to be a better option as long as the requirements are satisfied. Now, just to recap some of the benefits of this E2. So like I said earlier, 5-year visa, valid for unlimited entries, renewable indefinitely. Another major benefit is that upon approval, your U.S. company gets registered as an e-visa business. And this registration is key if you need to transfer anyone else to the States, because it's going to allow you to sponsor additional Canadian citizens, they have to be Canadian citizens, for employee visas. And the umbrella of eligible employees is generally much greater than what you see with that L1 category. So it is still going to be executives, managers, supervisors, but there's another option for essential employees. So this is going to include a lot of your technical staff and maybe even some of your technical staff that would not qualify under the L1. And it can also include maybe some managers, some lower level managers that are still essential to the organization, but maybe not quite high level enough to satisfy that L1 requirement for a manager. So in general, the umbrella is a little bigger in terms of the employees that can actually get visas and work permits. And you know, you're getting the 5-year visa. The longevity is just, it's unmatched from a work permit standpoint in the U.S. And indefinite renewals, as long as your company continues to qualify, you can just rely on this E2 visa for as long as needed. So yeah, so that's the E2. One of the last categories we're going to discuss is the E1. So Ruth, it is an E-visa. So tell us a little bit about the differences between the E1 compared to the E2.
Yeah, thanks, Zach. So the E1 is the sister visa to the E2. This is for Canadian companies engaged in substantial trade with the US. So this is, great for companies that need to bring their personnel over to the States to support ongoing trade activities. Some common scenarios include Canadian service companies with large US client base. Another way to look at it is for Canadian-owned US companies that is importing goods from Canada. And some of the requirements that need to be met is one, that of course the company must be majority Canadian owned. So at least 50%, and we need documentation showing that. Another thing is that the trade is substantial. So it's not just a one-time transaction, there's frequent transactions going on, and we have evidence showing that. And similar to what Zach said, the E1 has the same benefits as the E2. It's a visa for a 5-year period that is unlimited, and you can continue to renew as long as you still qualify. And you can sponsor additional employees under this visa type, and spouses are eligible for work authorization, which is excellent. And of course, other dependents such as children may attend school in the States.
Yeah, in the E1, for Canadian citizens, the most common scenario, at least what we see, it's going to be a Canadian-owned service company. Whether it's usually a business located in Canada that has U.S. clients. So you can be a consulting company, any type of service company. The industry isn't necessarily relevant. That's the most common scenario. And the E1 is a way to facilitate that cross-border trade. One of the, like Ruth was saying, one of the key requirements with the E1 is that substantiality requirement. It has to be substantial trade, and it also has to be principally between the U.S. and Canada. So the way we assess that is, and the way the government assesses that, is they take a look at a company's total revenue, and we want to break it down by country. And assuming that at least 50% of total international revenue is generated from the United States or potentially from the United States, then we can make the argument that it's principal, and substantial is based on the value. One contract in and of itself generally isn't sufficient. It can be if it's going to involve a ton of transactions and the contract itself is extremely valuable. Say it's the one contract is, more than 50% of total revenue for the whole organization, and it's for multiple years involving multiple transactions. Yeah, we can likely make an argument that that meets the substantiality requirement. However, a stronger case, what's more common is multiple contracts, multiple clients, multiple transactions, and multiple contracts of value. Because what the consulate's looking at is they want to see that the total amount, the total number of your international trade is sufficient enough to support the treaty investor and their family, enough to generate, it's enough income to support the family and the actual treaty trader. So the E1, like the E2, can be a great option. The 5-year validity period is incredible. There's not a lot of work permits in the U.S. that offer that type of longevity. So the E2 and the E1, those are really great options for Canadians. Just to recap, before we let everyone go, just to recap, we talked about the TN, the L1, the E2, and the E1. For professionals, for individuals in professional occupations, you have a job offer from the U.S., the TN is usually a go-to option, at least assess whether you're eligible or not. It can also be utilized by companies that need to, send their professional employees to the United States to provide services. You can sometimes sponsor those employees if you're Canadian. So there's a lot of flexibility with the team. The L1, this is your multinational organization. This is transferring managers, executives, and specialized knowledge employees. If you have an office in Canada and an office in the U.S., or maybe additional offices outside of Canada, and you need to transfer these personnel to the U.S., the L1 is usually the go-to option. It can also be utilized to establish a new office, just like the E2. The E2 and the L1 can both be utilized by entrepreneurs, individuals. They can be utilized by existing businesses that just want to expand to the U.S. market. Think of these as we want to set up shop in the U.S. and we want to transfer employees to the States. The E-2 offers better longevity. It includes more employees eligible for employee visas, but it is going to take longer to obtain. The L-1 can still be utilized to open that new office, and it is quicker to obtain. And then lastly, the E-1, this is the treaty trader visa. This is for companies engaged in international trade. Most commonly, it's Canadian service companies with U.S. clients and the need to transfer personnel to provide those services, or maybe it's the business owner themselves that need to enter the United States to engage in substantial trade. Either way, the E-1 is a route to facilitate that those cross-border transactions. So yeah, those are the four big options for Canadian citizens. They're the most commonly utilized, and they're just in and of themselves really good options for Canadians. Some of them are specific to Canadians, like the TN. But that's all the information we have for you guys today. If you have any questions, if you want to talk about any of these categories in depth, don't hesitate to contact our office. Also, be sure to check us out on social media. We post on YouTube and LinkedIn, Facebook. We have a lot of social media, even TikTok. And we do these webinars monthly. So if you're interested in learning more, you want to check out some more of our stuff, we do 2 webinars a month. We also have a very robust social media presence. So check us out. Feel free to reach out if there's anything we can do to help you.